Want to welcome everybody to our first exit planning forum live stream discussion. Today I'm joined with Jay Karamourtopolous, uh, my partner in crime and exit planning, and my good friend and business attorney, David Rodriguez of Richards, Rodriguez, and Skeeth. And we're going to be talking about navigating the 5 Ds of exit planning for business success and the power of proactive planning. Super excited to be here with you all. I just wanted to share the importance and significance of having a plan. Okay, here's the reality. If you are listening to this, whether live or the recording, and you are a business owner or an entrepreneur, or you know somebody who's a business owner or an entrepreneur, 100% of people will exit their business. Okay, I'm going to say this to you again. It was 100% of people will exit their business, and it will either be by design or it'll be by default. It'll be intentional or accidental. So 100% of business owners will exit their business in some way, shape, or form. It's either going to be by design or default, intentional or accidental. Here today, we're super excited to talk to you guys about this. Here's what the 5 Ds are. Okay. The 5 Ds are death, disability, divorce, distress, and disagreements. Okay, I'm going to say it again. Death, disability, divorce, distress, and disagreements. These are the 5 Ds of exit planning, business planning in general. So I just want to pause here. And Jay, do you want to share from your perspective, what is the importance of planning for the 5 Ds? And then we'll have David share a little bit about what he thinks the importance are, and we'll kind of jump right into this discussion.
Yeah, we were chatting earlier about this, but there have been studies that have shown that 50% of exits are forced by one of the 5 Ds. So cumulatively, when you look at all of these in conjunction, there is as much of a possibility that one of them happens as that one of them doesn't. So this isn't some tail risk that a business owner is planning for. There's a 50-50 chance that one of these happens, and neglecting to address these, early on in your business stage, in your business's growth stage, is, kind of setting yourself up for failure. So, going through these one by one and coming out with plans and having the hard discussions around these as soon as possible, not only protects, the value that you've already created, but it enhances the value to outside buyers as well.
And David, from your perspective, what do you think is the importance or significance of planning around these 5 Ds?
Sure. So I represent quite a few closely held companies, and really at the end of the day, really what business owners should be thinking about is, who do they want at the end of the day at the decision table? Do they want a third party? If they don't do any planning, there's a high possibility that could happen. And really, don't they want to control how the equity in that closely held company is transferred, whether it's to a spouse, an heir, to a third party? So it's really important for them to, for business owners of closely held companies to open up a dialogue about what are their concerns, what are their plans for the future, and how do they see their company moving forward after one of these events occur.
I think that's paramount. I would share this for everybody who's listening is when you typically think about owners or entrepreneurs, typically 60 to 80% of their net worth is tied up in the business. And when you think about exit planning overall, what it is, it's just good business. And the most important thing I can think of is this. If you're an owner and you're spending all your time, attention, intention, and money, and you have a family, or you have employees, or you have partners that are counting on you, it's paramount that you plan for these 5 Ds, because what it says is I love you. I care about you enough. I'm thinking about you enough to think about, what I built, where I spent time to make sure that you're taken care of. So I'm super excited to talk about this. So David, when from an owner's perspective, what is the first thing they should do to prepare themselves to address these 5Ds? And what does that process look like from your perspective?
Sure. It really happens when the owners are thinking about forming the company, really. So when they form the company, most entrepreneurs are really excited about the future. They're focused on, and they're putting all their energy about how are they going to make this business work. But oftentimes, they form the company, they're off to the races, they're very successful, and then we'll stop to think about, okay, well, what if something dramatic happens to one of us? Let's just say in a two-person company or a three-person company. And so I've seen quite often that, a lot of companies can be very successful on their own, but if they don't really stop and take the time to think about, okay, let's do some planning in case one of us, dies during the term that the company's in existence, or one of us becomes disabled, or one of the 5D events occurs. What do we see? How can we protect what we're building versus not worrying about it and just moving forward? It's almost analogous to somebody thinking about it's not important to do a will because eventually you're going to die, right? That's a certainty. And so why not do something for the folks that you leave behind? And that goes to your point earlier, Eric, about caring for the ones that you leave behind, right? Really, when a company is formed, that's probably the best time to open up a dialogue and say, let's think about what happens in these events. And what could be really helpful is to have your legal team, your wealth team around you and helping those clients think about these things rather than having to deal with them once the event occurs. Because once the event occurs, there's a lot of difficulty that follows with it. And during this discussion, we can share some war stories about what has happened in those events where no planning has taken place, and what is left behind when people don't do it.
Yeah, I think that's an excellent point. I think the one thing that you said that I think everybody should make sure that they're paying attention to is that exit planning and planning for 5Ds should start in the beginning, which means when everybody's healthy, when everybody's level-headed, we should think about what happens if things go wrong, right? These 5Ds are things that can go wrong when running a business. And by no means, everybody who's listening, the 5Ds does not encompass everything that could go wrong or challenges you will face as an owner, but they will encompass a large majority of issues that you can plan for and protect. So sitting around at the table and starting to talk about, hey, if something were to happen to me or one of us, if you're sitting with partners, that deals with the death, that deals with disability, that deals with things like if we become in conflict around something, if there's issues in the business. So starting out, you have this conversation around the 5Ds, David. Legally, what sort of documents influence or deal directly with this from a legal standpoint with the 5Ds? Where's the foundation that we start as an owner?
Right. So as owners, there's several options. Let's just take, for example, some owners are creating an LLC. So in an LLC, one of the organizational documents is an operating agreement or a company agreement. In that document, and we can talk a little bit more about it later, but that document essentially is the company's playbook. It addresses who the owners, how the owners vote, how they meet, how profits and losses are allocated and distributions are made. But also within that document could contain provisions that are normally referred to as a buy-sell provision or buy-sell agreement. And those are provisions that would cover the 5Ds. What happens? What are the mechanics if somebody dies during the existence of the company? And so within that operating agreement, you can place buy-sell provisions that address the 5Gs. Or let's say you have a company that's already in operation and they have their organizational documents in place, you can create a standalone buy-sell agreement that really just focuses on, you know, how equity is transferred during the lifetime of the company, whether it's from a third party offering one of the owners to buy them out, whether one of the 5Ds occurs, and those types of issues. So there's different ways of addressing it. You know, if you're a corporation, you know, you can place that in a shareholder agreement if you want to. But what I see it most often is in the organizational documents, because, and that's good planning. And having said that, though, this document is kind of similar to a will. It's a living document, right? What might work when what might have worked when the company was organized may not really work 5 or 6, 10 years down the road. And so, you know, not only should this dialogue occur when the company is organized and started, it should be something that should be looked back on and updated as the changing, you know, the company changes, the company grows, and the needs change.
I think that's excellent perspective. So when somebody comes out and they draft their operating agreement, how frequently would you recommend that they review it? Is it every couple of years? Is it significant milestones? Is it anytime significant changes occurs in some way, shape, or form, you should run it by your attorney and see if there should be an adjustment? What are your perspective? What do you typically recommend as a rule of thumb?
I mean, in a perfect world, you'd want to look at it annually, right? That would be, hey, does this document still meet our needs? But realistically, you know, every few years is ideal. But I think it'd be critical if this closely held company is adding in a new member or a new owner, that, you know, before that occurs, it would be good to review the document with your legal counsel and say, does this really address where we are now? And does it really take into account? I mean, for example, you have a closely held company, you have a key employee you want to offer equity to, but that employee is getting up in age. Does the document really address that kind of concern about disability, death, or, you know, did this person in the past have financial issues? And so does the document really address it? So there's really no perfect or ideal time period to review them, but, you know, ideally once a year, at least every few years, but particularly if there's major events that occur, particularly with the ownership structure of the company, that would be an ideal time to review it with your legal counsel.
This is going to sound, I'm sure somebody has this question, but can an operating agreement be outdated? Can laws change that would affect whether or not the operating agreement needs to be amended? I mean, obviously we know circumstances changes, but is there anything that could make an operating agreement outdated?
I don't think so if it's written, right? So if you have a written buy-sell agreement and it's properly drafted and it really addresses the issues concerning the parties, one way it can be, you know, maybe not useful is maybe the mechanisms to create or to determine the fair value of the equity that could be transferred may not work. For example, what might have worked when the company was organizing as a startup may really have no bearing on the value of the company moving forward. So I'll give you a real example. So let's say company forms, they create a buy-sell agreement, and if in the event one of the 5Gs occurs, the parties have agreed, or the owners have agreed, that the value of the equity is $1 per whatever, whether it's $1 per unit, $1 per share, what have you. That might be well and good for the first year or so when the company is growing, but, you know, 4 years down the road, the company may be a much bigger company, and this valuation that was created when they formed really doesn't have a bearing to what the value is at the time that this event occurs. And so, you know, most buy-sell agreements will have a formula to create fair value, or would provide that, you know, if the owners agree upon a fair value, that they'll update that value at least annually. And if they haven't updated that value annually, then they could look to a third party appraiser. So there's, in that way it could become outdated. So, but from a drafting standpoint, the document really shouldn't be outlawed. I can't imagine a provision in a statute or a law that would outlaw the buy-sell agreement. I'm not saying that couldn't happen, but I haven't seen that in the past. But from a legal standpoint, it should be a flexible document. It should be updated occasionally, and should really just address the needs of the owners as it grows over time.
So we got a question that pops in here from Anthony Navarro saying, does a husband and wife company need different types of documents versus another company that has several owners and there's no familial ties? So if it's me and my wife in a business, is there a different set of documents that are needed versus, let's say, business with partners?
I think that, for example, if it's a husband and wife, in a typical situation, I mean, we live in Texas as a community property state. So if you're married, and let's just take a hypothetical, you die, your property is going to transfer to your spouse, right? And I think that, in my opinion, I think that a buy-sell agreement is critical when you have more than two owners, right? So when you have more than just a husband and wife, I think that in a situation where it's a husband and wife, the will should probably control, because I think that the property can transfer anyway. The only caveat is, and I have a real world example about this, is let's just take an example of an entity that's formed that requires a professional license. Let's just take a veterinary practice, right? Mm-hmm. So a veterinary doctor forms a PLLC or some form of professional corporation. The spouse of the veterinarian is not licensed as a vet. The vet dies, so then what? Right? I mean, even though the property technically transfers to the wife can't take over the veterinary practice because the spouse is not licensed. Yeah. So, in those kind of situations, in that particular situation, what would likely happen would be that the spouse would obtain the equity. The veterinary board would likely give the veterinary practice a reasonable amount of time to be able to sell that practice. And then the spouse would then end up with the value of that practice. But I've been in a situation where, in that particular case, where a solely owned veterinary practice, pretty successful, had retained 8 other veterinarians within its organization. The owner passes away, and the spouse then obtains the equity, and the board said, sure, you have a reasonable amount of time as the executive of the estate to sell the assets. Well, here's the big problem. Because there was no succession planning, the other veterinarians went off to other hospitals. So really they had to sell the assets at a kind of a fire sale, because there was really no available vet there to take over that practice, Right. So that's one of the downfalls of not doing any planning, succession planning.
Yeah, I think that example you gave can translate into all sorts of things, right? It can come into wealth management, can come into veterinarian, right. Medical, probably law, right? Yeah. It's these things comes across. So, what I heard is that there needs to be a conversation, even with if it's a husband and wife. Right. The thing that I think about when a husband and wife is, we're going to kind of jump right into one of the D's, is what happens if it's your husband and wife business and you become divorced. So my question to you, David, if it's me and a significant other, or my wife, and we form a company, how does this get outlined inside of the operating agreement, addressing divorce as one of the D's? Does that get addressed in the buy-sell agreement? I'm just curious, how does divorce play in as one of the D's? Because let's be honest, the stats say 50% of marriages end up in divorce. And with the amount of stress on entrepreneurs, I would almost say their 50% is probably more like 60 to 70% of entrepreneurs end up divorced.
Right. So, this issue of divorce can be within the operating agreement, or it can be in a standalone buy-sell agreement. And so really, you know, in a closely held company, the owners really don't want to be in a position to have a disgruntled ex-spouse at the decision table, particularly if the ex-spouse has no, you know, has no interest in you know, helping the business, doesn't have the expertise to help the company grow, and is upset about the divorce itself, right? And so how this is addressed, whether it's an operating agreement or buy-sell agreement, is upfront, you know, there is a provision in the operating agreement or buy-sell agreement that provides if an owner does get divorced, and if any equity is transferred to the spouse through the divorce proceedings, there's a mechanism in place where that spouse upfront agrees that the owner or operating spouse is permitted to or given a first option to acquire that equity at a fair value or at a value agreed upon. And so day one, you have this agreement in place, and then you have the spouse, you know, and I would recommend that the spouse obtain their own lawyer to help them, you know, look at this. But the spouse up front consents in writing to be bound by that agreement, by that operating agreement. And so that's step one. But then step two, each of the spouses, you know, the owner spouse and the spouse themselves should provide in their will that if they pass, then the equity goes back to the owner spouse, or the owner spouse has the ability to acquire that. So cover it while you're alive and if you die. So it covers the divorce and it covers the death part. So you need to cover them both because, you know, it's unfair to the other owners, particularly if there's more than one, to have a disgruntled ex-spouse there because, and I do have some stories about that as well, that we can either talk about now or we can talk about in a few minutes.
Yeah, let's come back to disgruntled ex. So Anthony also asked what documents are used in succession planning or exit planning. So I'll kind of summarize what I think they are. And so the first thing that's needed for a successful succession plan is it's not even a document. It's to actually sit down and think about what do you want to have happen if each one of these 5 Ds occurs in your business, right? Who's going to be impacted and how do you want to plan for it? So it's have a meeting either with yourself or with your partners to talk through these things, and then to have a meeting with your professionals, whether that's your wealth advisor, your business attorney, your CPA, and to make sure that everybody's on the same page. So that's document process number one. Second one is you need to understand what the value of your business is. So have a valuation mechanism, whether you bring in an outside third party, whether you use some form of a multiple. So understand what the value is. The third one is to have your operating agreement and to have a buy-sell agreement in place if there's multiple owners that are not family related. Would you agree with that, David? That's kind of a synthesis of what needs to occur from a successful succession plan?
Yes, that is true. And the other thing I would add to it is that you should have a will in place, right? The will should address that issue so that there's no conflict between the succession planning that you've done during your lifetime and what occurs when you die. So, you know, you should rope in or include your estate planning professional to help you with that as well. And you know, what works for company A may not work for company B and C, right? And so it's an individual choice. And I've seen a lot of companies be very successful about it. And so, you know, the dialogue, either an operating agreement that addresses the 5 Ds or a standalone buy-sell agreement that addresses those 5 Ds and their will. You know, what I have seen, even though I don't practice estate planning, is what I mentioned earlier during our conversation is people don't want to really think about dying and they don't want to plan for it, right? But it's going to happen. So might as well do some planning about it. And even if it's just not about the money, it's about the stress that you leave behind when that happens to your loved ones or, you know, the people that you leave behind.
So when you think about the 5 Ds specifically, and we think about, you know, this planning that occurs, which, from your experience, which one of these 5Ds is most prevalent that you've seen play out just from the different war stories that you referenced that you've experienced over your career counseling companies?
It's a great question. I mean, I haven't really thought through that much, but as far as war stories are concerned, the more difficult ones have occurred as a related to death and as a disability, actually, because although you might think that you're always going to be active and healthy, disability can mean a lot of different things, right? It could mean you're ill, you're in a bad car wreck, and you are incapacitated for a long period of time. You could go missing. You could end up in a deserted island. I mean, things can happen to a company's owner that people don't really anticipate. But if a disability occurs, for example, and really at the end of the day, you have the most difficult conversation is what does disability mean, right? Because it can mean a lot of different things. And so what I've seen often how this is addressed is if someone is unable for whatever reason, whether it's due to illness or what have you, to participate in a business for a certain number of consecutive days, they are considered disabled. Or if the company believes that one of the owners has, whether it's through a mental issue, through a drug issue, through an alcohol issue, and they're incapable of operating and performing in their business, the company, in the agreement, the company can retain a third-party doctor or physician to actually examine that person. You agree upon this, ahead of time. The company and the other owners agree to abide by the physician's determination. And so really at the end of the day, it's really not fair to the other owners to be sharing profits, assuming the company is profitable, with somebody who's not participating in growing the company. That could also occur on a death, right, where you have an heir or a spouse for someone who's passed away, and they want to hold on to that equity because it's a profitable business, and they're just, they get mailbox money, so to speak, but they're not participating. That creates a lot of issues for the company, the owners that are left behind. And so I've seen quite a few of those types of situations. But believe it or not, I mean, disagreements can really play a part in wholesale companies too. So, and I know I'm not really answering your question specifically, but
you're not. You're answering the question. So I guess my question to you is: so you've put in place the operating agreement, you've done the buy-sell agreement. One of the things that we see with companies is they've done these things, but they have no funding plan for the buy-sell agreement, right? They've done no funding, right? So for those of you that are listening, this is where funds, there is no money fairy. This is where funds are going to come from. Okay, funds are either going to come from cash flow from the entity to buy out said owner, okay, which none of us here are evaluator, but we all understand business, which is going to affect the valuation of the business if that's the case, because a significant cash is going to come out of some sort and there's going to be a discount. Funds are going to come from loans that get secured with the bank, or funds are going to come from some sort of an insurance policy. So in the case of disability, that would be income protection, that would be disability buyout insurance, that could be business overhead insurance, right? These are all sorts of things that could occur. In the case of death, that's going to be things like life insurance for owners and for key employees. So one of the things that I see issues with, David, and I'm curious from your perspective, is a lack of a funding mechanism for the buy-sell agreement. Is that something that you come across a lot when you talk to folks?
I come across that quite a bit. And so really, if there's really been no planning about it, and if the owners haven't addressed this issue with their insurance professionals or their wealth professionals, typically the default is let's come up with a promissory note, right? Let's use the the funds of the company to stretch out the payments over a period of time reasonably, with a reasonable interest rate. A 50-year note doesn't work, but maybe a 3 or 5 years works, right? So the hope is that the company stays intact, the company's cash flow permits the company to continue in existence and service that debt. But ideally, owners should visit with likely their wealth advisors first. Like, okay, we have this thing that we want to put in place, this protection mechanism, but we don't really anticipate or neither that, or we really don't know what's going to happen in the future. What are the things that we should kind of be putting in place? Should we be looking at what kind of insurance should we look at? What kind of life insurance policies should we have in place? Do we need a key man policy? What do we need? And that's where I think the wealth advisors like you guys can really help a client plan for that future. So, it's rare where everything is just put in place and everything goes as clockwork. So, we're all human. So, it's really hard to plan for everything. But, if you don't do any planning, it's guaranteed that you're going to have a lot of issues. If you do some planning, I think you're going to alleviate a lot of problems in the future.
So we talked about death. We talked about disability.
Yeah.
Let's talk about something that's probably people don't even think about when they think about the D's, which you kind of alluded to, which is disagreements.
Right.
I don't know about anybody here, but if you have to do something in a group setting, sometimes there can be disagreements. Now add to the fact that you're dealing with money and you're dealing with egos and you're dealing with people's personalities, and you are going to have disagreements. Doesn't matter how much you like somebody. Anybody who's listening to us is married knows that you will have disagreement with somebody that you care about. Okay. And so when you talk about disagreements and incorporating that into the planning process, how does that get addressed inside of the operating agreement? And how does that get addressed inside of a buy-sell agreement? I'm assuming that doesn't. So let's just say the operating agreement, because when owners disagree, et cetera.
Right. So there's a big difference between disagreeing what type of color to paint the walls, right? Versus whether one of the owners wants to shift the operations in one direction and the other owners want to shift the operations in a completely different direction, really. So you get to a point where it's a fundamental business issue concerning the company that the owners just really cannot agree upon. So how that is addressed is typically you will have some conflict provisions in your operating agreement or buy-sell that the owners agree up front to negotiate with each other in good faith. Let's try to work this out before we escalate this, right? And good faith means that you're open to hearing the other folks out, that you are willing to concede to issues, and you negotiate in good faith. You could escalate that to where the parties can bring in a third party to help mediate the dispute, right? Whether it's a retired judge or a third party lawyer or somebody. And if they really just get to the point where one party just cannot agree, then you could put in place a mechanism that's called a push-pull provision. And so how that mechanism works is, let's say you and I, Eric, own a company, and you and I just can't agree upon it, right? And we have this mechanism that's called a push-pull. So one of us can make an offer so let's just take a hypothetical. I can tell you, Eric, I want to buy all of your equity in 10 days, cash for $1 million. Okay. So that I've made a push. And so then you decide either you're going to accept that offer or that push in 10 days for $1 million in cash, or you're going to mirror that offer back to me. But at the end of 20 days, either you're going to own the company or I'm going to own the company. There's no ifs, ands, or buts. So once you pull that trigger, something's going to happen within the time frame of the initial push. Now, having said that, a push-pull doesn't always work. So if you're a billionaire and I am just barely scraping by and living on credit cards, a push-pull is never going to work because you're always going to be able to take the company. I'm never going to be able to match your offer, regardless of how hard I try. So, a push-pull is a good idea to address disagreements when, the owners are in relatively similar negotiating, positions. But, even if we don't have a push-pull, there should be some conflict resolution provisions in there to manage, particularly if there's a company that's owned 50-50 by two people, because you're talking about a deadlock position, right? So if I want to go left and you want to go right, we're deadlocked, and what are we going to do? So you should have some mechanisms within the agreement to help try to get it. And I've even seen it go as far as a coin flip, right? So first,
you heard it here first, folks. Your business success will be decided by a coin flip, so you will leave it to chance.
Yeah, but that's an extreme measure, right? So you negotiate in good faith, you mediate it, and you just can't come to it, and that's an extreme, mechanism. But hey, I mean, it's better than going to court or shutting down your company because you can't agree.
Yeah, I can appreciate that. Here's one of the other things that I would add. When you think about this state of small business where it sits today, here's some of the stats for some of you listening, and we're going to kind of dive in how it ties into the D's. As of today, there are 33.2 million small business owners as of 2022 stats. Close to 40% of them are baby boomers, people between the ages of 59 and 77. So when I think about that, that means that here's a couple of the D's that are really on the horizon, every single one of them. But let's just give you some stats. 67% of Americans have no estate plan. 67% of people above the age of 55 don't have a durable power of attorney, aka a financial power of attorney. 65% of people don't have any healthcare power of attorney. Okay? When you start thinking about age demographics, 40% of business owners are baby boomers that have done no estate planning. Then you have distress, right? We didn't even really hit on distress yet. Distress came in 2020 for a lot of us with COVID, right? It amplifies this sort of a conversation. So what sort of language, I guess, David, gets incorporated into the agreement? We talked about the operating agreement being the business's playbook. How does the operating agreement, or how should a business go about planning for distress from things like COVID, cash flow, data breaches, etc.?
Yeah, so where I see it most often is because in a distress situation, it's typically when somebody is suffering from financial distress, right? Somebody is overextended on taxes, or they're past due on taxes, they're overextended on the credit cards, what have you. And so for a closely held company, really, if one of the owners becomes financially distressed for whatever reason, whether it's related to COVID or it's just bad debts on real estate, what have you, right? Does the company really want to expose itself to potentially having a bankruptcy trustee or a creditor own the equity? So what happens is somebody seeks bankruptcy protection or insolvency protection, or a creditor forces one of the owners into bankruptcy. Likely going to happen is that a bankruptcy trustee or that creditor is going to end up with that equity. And so really at the end of the day, the trustee is really charged with gathering as much funds they can for the creditors. And the creditor wants to get every penny they can, but probably likely willing to get rid of that equity for anything, really, because it's better than zero, right? So how the operating agreement or the buy-sell provisions address this is that if somebody seeks bankruptcy protection or insolvency protection, or a creditor initiates that type of action against one of the owners, that typically takes a little while. And so a provision would be included that says, if that insolvency proceeding is not dismissed within a certain number of days, and I typically don't like to go more than 60 to 90 days, but preferably 30 to 60 days. So there's the owner has to get very creative to try to prevent this from happening. then the company and the other owners have basically a first right to acquire that equity based upon a fair value. And so the fair value could be a set number, it could be a formula, it could be by agreement, it could be, through a third party appraiser. But what I like to refer to these 5Ds are basically their triggering events. If somebody dies, a trigger's hit. Somebody becomes disabled in a manner in which we've all agreed upon. It's triggered. These provisions are triggered. And so there's a recurring theme. The company should first have the option to get that back, because what happens is if the company gets the equity back, all the other owners' equities percentage increases, right? And so, if the company doesn't have the funding to do that, you might have individual owners that have the ability to do that. So they may want to acquire the equity. And then if both of those options don't materialize, then whatever happens to the equity happens. It goes to an heir, it goes to a bankruptcy proceeding, it goes, spouse, what have you. Yep. But in order to protect the integrity of the company, it really should stay within the company or its owners. So, and if that provision is adequately drafted for the distressed issue, you don't have any concerns that a bankruptcy trustee or creditors can end up with the equity.
Got it. So you brought up an interesting. I mean, bankruptcy didn't even cross my radar, but it was an excellent point around that. So, what about? And we've got a question from Anthony again. He says, how should an owner exit or plan for their exit if they want their kids to be involved in the business? Like, is there anything that they should be doing with regards to, the operating agreement? And obviously you don't practice estate planning, but I know from having dealt with it, there needs to be some sort of language there around inside of the estate plan, the wills, the trust, et cetera, to that coordinate. So from an operating agreement, how does an owner ensure that his children continue the legacy of the business?
That's a great question. And so it really depends. And I hate to say that as a lawyer, but it really depends, right? So if you have an entity that requires licensed people to run it, really the best you can do is ensure that funds or the value of your equity goes to your kids. If you're in a closely held business, it kind of depends upon whether the other owners are open to your kids, being part of the ownership structure, right? If you and I are owners and you've got bratty kids and I know it and don't like them, do I really want them as part of my company? But really, and joking aside, right? I love your kids, but
allegedly. So when we think about this, we talk about the D's, right? Here's what I've heard so far. It's plan before something happens, review regularly, check in with your team, as changes happen in the business, and rely on them and make sure that your documents are updated on a regular basis. So let's talk about war stories now of where things can go wrong with lack of planning. So why don't you share a few from your perspective, and I may have a one or two, David.
I did have a question.
Yeah, please.
David, you mentioned it a few times, the alignment between, as exit planners, we like to call them the three legs of the stool: personal, business, and financial. When it's the case where the will and the operating agreement conflict, how does that typically play out? And the second part of that is, just brings to light the importance of working with multiple team members who understand how all of this works together. You can see how if the wealth advisor is siloed from the attorney or the CPA, this can cause massive issues and cause misalignment within these documents.
Right. I think kind of the baseline answer to your first question about what happens when there's a conflict is you may end up in litigation, right? What was the intent? You have a document that is the playbook and operating agreement of the company. And despite that, despite all the effort put in a document that covers this, you have a will that's completely contrary. And so it's unclear how that ends up because you never can tell what's going to happen if a judge or jury gets a hold of it, right? But as it addresses your second, and if, certainly if somebody's living, right, and so the will is not in probate, you know, and the company's been in existence, it's a great idea to have whoever your legal counsel is and your wealth folks and your estate planners to all be on the same page. I mean, it doesn't really make a lot of sense when the left hand doesn't know what the right hand's doing, because you spend a lot of time and effort on one document only to be overridden by another document. That doesn't make sense. And so I would encourage closely held businesses to take a moment to incorporate, bring in their team, to have a team, to have a legal counsel, to have a wealth planner, to have a CPA and have a estate planner, and insurance folks, and encourage them to talk to each other and share the documents, because this is really something that, owners have, it's their baby, it's their company, it's just something that they've started from zero and have grown into something. And why waste that? Why waste all that time and effort? So I think I addressed both of your questions, but I think it's, there's nothing better than communication with the folks that you trust, that you've built around you, to not keep them in silos, right? To allow them to talk to each other, to allow them to be on calls when you are talking about planning for inevitable death or what have you. And so it could go a long way to making things work a lot easier. So war stories.
Yep.
I once represented a law firm, and it was during COVID. And within the law firm, there was a business attorney. Well, at the time that they were applying for a PPP loan, they didn't have an operating agreement, believe it or not. So, lawyers are the worst clients, right? And so, this is, the other partners leaned on the business lawyer to put together something. And of course, it was put together very quickly. Wasn't really a lot of thought or dialogue around it, just to get the PPP loan. Well, after they received the loan, the other partners started to notice that this business lawyer was having drug and alcohol problems, was, berating, staff, wasn't working on clients' files. And so, the firm was in a very tough position because, if they would have planned a little bit and had some disability provisions, to address this person's incapacity to practice, they would have been in a much better position. And so there was a new provision in the Texas Business Organizations Code, which basically governs how businesses in Texas operate. But we were able to include a new provision in the operating, and we amended and restated the operating agreement because all the other owners or partners wanted to do that, except this one business partner. And it created a mechanism where the other owners could potentially vote this person out, because they were facing malpractice claims, they were facing, a lot of other problems relating to the drug and alcohol use. And luckily in that case, the business lawyer voluntarily withdrew. But what could have happened is if he decided to stay in, likely this would have ended up in not only litigation, but the firm would have been subject to likely a number of malpractice claims because the clients were not being serviced. Also helped an aviation company. Revenue exceeded $100 million, owned by two people, 50-50. So it was something I alluded to earlier in our discussion. And the owners are in their 70s, of all things. And so in this case, one of the owners is very open and attempting to start the dialogue. This company's been around for a while, but wants to open the dialogue about succession planning because the other owner has kids that are in trouble financially. They want to get involved in the company, but the owner that wants to do some planning doesn't want anything to do with it. This goes back to your earlier example about kids, right? Does not want the other kids to be involved. But without any planning, we're kind of stuck, right? We're at a 50-50 situation. We're trying to open up the dialogue now, years later, and there's no way to tell what's going to happen. And so if one of the 5 Ds occurs to that other owner, I'm thinking that it's going to be very detrimental for the company moving forward, if it moves forward.
Yeah, I got a great example that kind of dovetails a couple of things I want to highlight here because Jay brought this up and David talked about it. It's important that you have a coordinated approach to creating a plan around these 5Ds, which means that everybody needs to communicate with that's on your team with each other. You're everybody, right? So don't put people in silos if you're listening to this. The second thing is it's really important that you review your agreements. So often when owners start their business, for those of you listening, they hodgepodge things together. They're doing things hurriedly and things have changed. Unfortunately, I've seen these folks create operating agreements off of online legal services that are very boilerplate, et cetera, or they've somebody gave them a template for a buy-sell agreement that they copied. And so it's super important that you have a coordinated approach. Exit planning can be thrust upon you, and here's how it goes. I have an actual example. Client, approached me a couple of weeks ago and says, my construction company is exploding. Private equity, reached out to me. My company is worth $30-40 million. And now that I thought about it, I don't even want to consider selling the private equity. And I actually care about my employees and I want the business to stay intact if something were to happen to me. And so in that dialogue, we determined there was no key man insurance in place. There have not done a formal valuation outside of the offer that got thrown onto them. And they hadn't even explored different options. So one of the things we brought up to them was like, hey, if you thought about an employee stock ownership plan, that might be something that you might want to consider if you want the business to stay with your employees, et cetera. And he said, I didn't even think about that. So exit planning is about exploring all your options and then bringing your team together. So David, I think you got another example you wanted to share.
Yeah, so an engineering company, right? So it requires certain skills, licenses, or what have you. It was formed by 4 individuals. One who, no planning. One passed away, and the equity for that one owner then transferred to the spouse. The company is pretty successful, so there's mailbox money. But now that the other 3 owners or the founders really want to sell the company, they want to prepare it for sale. They have some potential buyers, and their organizational documents require that in the event the company is ever sold, it requires unanimity, right? It requires unanimous consent of all the owners. Guess what? The surviving spouse has no interest in selling. So now they're kind of stuck. What are they going to do? So now they're trying to negotiate a buyout of her, and likely they're going to have to pay quite a bit more than they would have had to even if they had sold the company. So she's going to take more of a piece of the pie than she probably should be entitled to. But at the end of the day, the other 3 founders really want to sell the company. But they're kind of stuck. They're dependent upon whether they're able to reach an agreement with her or not.
So when you write out these, so when somebody comes, somebody's building out the legal documents to go with their exit plan, is it paramount from your standpoint to build flexibility and frameworks in these documents? And then, if somebody comes to you or any business attorney, is there practical advice? Do you help them see around corners like this that they might not even thinking about?
Well, one thing I didn't mention is in Texas, you don't have to have an operating agreement, a written document. So what the Texas Business Organizations Code provides that if a company does not have a written operating agreement or a company agreement, then the terms default to the statute. And 99% of the time, the statute's not going to address issues that owners are concerned about, right? Because every company is very unique. But my first advice is have a written document that clearly outlines your concerns and addresses them. Have that document be a living document. Don't just put it in the drawer and let it collect dust electronically or otherwise. You could come back to that document and occasionally, annually, every couple of years, and see if it really does address the current needs of the company and its owners. Make sure it's easy to understand and follow, right? So if you create a 100-page document that no one really, the owners really care to understand, and it's so overly complicated, it's so difficult to follow through on, that really doesn't help anybody, right? So it should be clearly written and understood. And so, and it should address the concerns of not only succession planning, but how the company moves forward if there are disputes, or if they're voting, how do people vote? How often do we vote? What are the things we vote on? How many, what percentage does it take for us to pass things? And as you become a bigger company, that really kicks in more. But it should be a living document, just like a will should be. It should be something that really kind of addresses, what keeps owners up at night, right? What are the pain points that they have, and how does it address it?
So quick question that came to mind as you were talking about this, because my brain's always tinkering. But when you think about these Ds, and you think of, you talked about fair market value as far as evaluation for the company, is there a way to put a provision, and would it make any sense to say, a predetermined valuation or fair market value, whichever is lower? Because I think about owners and these situations like the one you described with this engineering firm, that they're now having to overpay for something. Is there any sort of language that you could put around, stipulating the valuation, that it's either one of the two and it's a lesser amount, or something to that extent?
Well, it depends on what the owners want. I suspect that if you're an owner of a company, you're going to want the higher of the two, not the lower.
Correct. Yeah, but if you're the remaining owners, you want the lower of the two, not the higher of the two.
That's where you have the tension. And so it's just all about opening the dialogue, right? And really, at the end of the day, not only should the document be workable for the owner, but it should be fair. It should be fair to not only the other owners that you leave behind, but it should be fair to the folks that end up with the funds, right? Whether it's a spouse, or heir, or what have you. And so, there's really no perfect way to draft around this, but it really, at the end of the day, if it addresses the concerns of the owners, and it evolves as the company grows, that's probably the best you can do. And like I said before, what might work when you're a startup, probably not going to work when you're a mature company. And so that's where things really kind of shift a little bit. And the company's lawyer should, and their wealth advisors and their CPAs and their estate planners should kind of help the owners kind of focus on, really, does what you have in place really, address your needs now? You're not a startup anymore. You're a successful company. So that's the best I think that can happen. In my opinion.
Thank you. So we're getting close to the hour here for everybody that is listening or will be listening. So I want to, number one, I want to thank everybody for listening in. This conversation around the 5 Ds and how you can safeguard your business and do some proactive planning with Jay and David has been enlightening. There is a lot in this subject. We will be having David on to discuss further around these 5 Ds and exit planning in general. We mentioned this in the beginning of the call. 100% of business owners will exit their business. It's either going to be by design or it's going to be by default. And if you're listening to this, it's super important that you start the conversation now and you start to think through these 5 Ds. What do I want to have happen if I don't wake up tomorrow? That's death. What do I want to have happen if I can't work anymore? That's disability. What do I want to have happen if me and my spouse are no longer together? What happens if me and my partners disagree? And what sort of serious and proactive business planning do we have in case there's some form of distress, like bankruptcy was an example that David mentioned, could be cash flow challenges, could be COVID, etc. So I want to thank everybody for listening, and we hope that you have an amazing finish to your week, and we're appreciated for your time today. Thank you so much.
Thank you.
Thank you.